Well, I think very little, because an internal auditor's role is to look at controls, to make sure that controls are adequate and effective. So whatever they did, you know, you can have systems, and you've got the King Code, for example, but if you have dishonesty and you have the Public Finance Management Act, so you have legislation, you have a code, you've got internal auditing, you cannot stop dishonesty. So the Public Finance Management Act, interestingly enough, when it was passed back in 94, 95, no, 2004, I think, whenever it was, it was said, we want directors of state-owned companies to really act honestly and competently. And my response was, why have we developed this very complicated Public Finance Management Act with a draconian 5-year prison sentence over the head of people, so that they're spending up to 60% of their time ticking boxes mindlessly, instead of performing, which you and I as taxpayers want them to perform. And yet they are conforming to all this. And yet we know that there has been dishonesty and corruption in our state-owned companies. So it's a clear answer to your question that to legislate about these things, to say draw code, is not the answer. You've got to change, you've got to cross what I call a self-river. You've got to leave behind self-interest, self-concern, so that you take risk for reward. So you cross, but you cross the river into the area of intellectual honesty. That honest application of mind in the best interest of this incapacitated, inanimate, artificial person, the company, that has no conscience. The conscience is the conscience of the leaders, the corporate leaders. So the company, through the 20th century, there was an outrage from society. Look what these companies have done. They've polluted the earth. The company was innocent. It was the way the directors steered the company. So I gave a talk months ago. I said my talk is about an oxymoron, lawful wrongs. Directors with a shareholder-centric model to increase the wealth of shareholders instead of focusing on the long-term health of the company, drove the company at a cost to society and adverse impacts on the environment. The company was innocent, but society saw the company as committing these wrongs against society. And what was the reaction? Regulators regulated that the company mustn't do this, mustn't do that, that's adverse to the environment, and so added to the cost of production. So the extraordinary thing when you analyze that is, these wrongs were being committed against the environment and society, and yet the regulator passed regulations to try and improve these adverse consequences at a cost to members of society, because the cost of production of the product went up. Whereas integrated thinking and integrated reporting takes it back at source into the boardroom, where the board, that collective mind of the directors, has to be applied, this business model, how the company makes its money. Will it have a positive or negative impact on those three critical dimensions? If it's negative, what's our long-term strategy to eradicate or ameliorate it? If it's positive, how are we going to enhance that? And that's what responsible investors are looking for. Well, they've got a huge issue. They have to become whistleblowers. And I am concerned about the whistleblowing legislation in South Africa, designed to protect the whistleblower, but it's not doing that at all. And I think the reason for it is it's fragmented. We have whistleblowing protection, in inverted commas, in the Constitution. We have it in the Public Disclosure Act. We have whistleblowing in our Companies Act. We have whistleblowing and protection in our Labour Relations Act. None of those acts say or encourages people inside those organizations to actually come up and talk about something which is remiss. None actually says society, a whistleblower must be respected and honored. They've got a whole lot of other language, but it's a question of, it's the most extraordinary thing, and you know what I'm talking about, that a whistleblower happens and suddenly they get ostracized. And it's the most incredible thing. So there should be, I think the legislation needs to be more positive, to say that they must be respected and honored by society, you know, as a critical part of society. So I think what we need is an overarching whistleblowing piece of legislation which encourages people to talk and to talk to authorities. So we've got, for example, now a Prevention of Corrupt Practices Act. Any conduct or omission over 100,000 rand which is corrupt, you're obliged to report it to the police. Well, I'm not blaming our police. They're trained for what I call physical crime, assault, murder, rape, etc. They're not trained for commercial crimes. And they're not forensic specialists. And so you can report it to the police, but it'll drag on and on and on. And if it appears in court, well, the prosecutor probably knows how to prosecute an assault case, but go and prosecute a very complicated commercial fraud and everything. He's lost, and you've got an experienced corporate advocate for the defense. End of story. So it's very important that I think that you have dispute resolution clauses in employment and supply contracts. So when there is a dispute about employee A has siphoned off money and has gone around a control developed by the internal auditor, that you can have it resolved within 60 days with a dispute resolution clause. You know that litigation today, by going up to the Concourt, can take 4 or 5 years. Well, 4 or 5 years, you've got a dishonest person, let's say, on suspension under the Labour Relations Act, and paying him a it just becomes, I was talking to a very senior non-executive director yesterday, a lady, and she said she can't stand it. She's a director of this company, and they want to get rid of this one senior executive, and they just cannot. They've got to keep going. Now, if they had a dispute resolution clause, 2 weeks negotiate, 2 weeks mediate, next 2 weeks, if you don't resolve it, the Arbitration Foundation of South Africa appoints an arbitrator. He decides you get an award, you haven't made an order of court, you execute against it, and that's it. Then you use that to dismiss him. And now comes, some of those people have also become directors. So if you don't have, you must build into your, I believe, your memorandum of incorporation, the right of a board, which is suggested in Section 71 of our New Companies Act, the right of a board to remove a director. Otherwise, you've got to call an extraordinary general meeting of shareholders and set out the reasons why you want to remove that director, and he's got a right to reply. And then you call the extraordinary general meeting. So let's go to the private sector. Let's say there's a shareholder that owns 60% of the equity, and he phones me as the chief executive and says, Mervyn, I've had this notice to remove George. You know, George has been a member of our golf club for the last 30 years. And he's actually a very decent chap, you know, and I think you should give him another chance, you know. And so he comes to the extraordinary general meeting and votes to keep him on the board. Now he's on that board and you're acting as a collegiate. The whole board becomes dysfunctional, and that's what happens. So I think it's better to make it absolutely clear. You write into your MOI that if there's something, the board comes to the conclusion that this director is a delinquent director, for whatever reason it is, that the board has the right to remove that director. And you get an end to that dysfunctionality. I think the IIA has to sit down and really draw a standard contract, because at the moment the internal auditor is very exposed to a claim for damages when something goes wrong, and joint and several liability. So you can have, today you can have in a major company, you can have an internal audit team of 70, 100 people. And let's say one goes rogue, and you've got joint and several liability for all of them. I mean, it's just, so it smacks of inequity and unfairness. And yet, the law as it stands at the moment, under breach of contract, you cannot apportion blame. But you can indeed, so like at an uncontrolled intersection, you and I collide, you going slow, I'm going faster, the court will make me pay more of your damages, you pay less of mine. But now you and I in a contract, I breach it, and you sue me. But actually, there was the chief operating officer or someone else also did something wrong which added to the breach. I can't join them and say court apportion blame. That's the Supreme Court of Appeal in the thoroughbred breeders case. I think that's inequitable, and I think it's got to be built into the contract, because there's nothing to avoid doing that by way of contract, into the internal auditor's contract, that if an internal auditor or the team is sued, that they can join then the chief operating officer and say, look, there was a failure here, but it wasn't we weren't the sole cause. It's exactly the same when something in the corporate failure and the external auditor gets sued, so one of the big four gets sued because they've got the deepest pockets. But you as a journalist know there is not one case that you can show me that where there's been a corporate failure, the sole cause is because the auditor failed to properly apply one standard of auditing. When you think about it, it's laughable. And yet, that's what happens. They sue the auditor and the auditor pays out, and the auditor can't apportion blame. It just smacks of inequity and unfairness. So I believe the Apportionment of Damages Act has got to be amended, but until you do that, you've got to change this by way of contract. And I think there's got to be developed with the internal auditor a standard contract that they can ask a court, even though they can't join, but say to the court, it's been agreed between the company, my employer, and me, that if there's an internal audit failure, well, you sue me, it's fine, but I can say, I'm not the sole cause of this loss. It was the chief operating officer, the supplier supplied the wrong part or something, whatever, and caused the failure of the company's product. So I say, just apportion blame, I'm 20% to blame. I think that's fair. And it's reasonable. And that is what happens in other countries. But in our country, we can't do that. The Apportionment of Damages Act is limited to just a delictual situation and not a breach of contract.